Hello everyone. Uh, Let me introduce myself. My name is Makran Joshi. I'm a practicing company secretary from Mumbai, and this recording has been organized by ICSI, and we are running a practicing company secretary firm from Mumbai, and also have been very active in institute. Also member of Secretarial Standard Board. Your three, which is the classic favorite. So institute has asked me to speak on interpretation of statutes and particularly on internal external aids, various rules of interpretation, along with some case studies. And in this context, I am here in front of you to speak on interpretation of statutes. Now, what I will do is I will share my PPT now on the screen, and I will be I will be narrating my views and thoughts on this interpretation of statutes. So I'll start the PPT now. Interpretation of statutes. It has been a subject very near, dear, very close to me, and I have been a very follower of this subject, interpretation of statutes. Actually, this subject was taught to us when we were running company secretary, when we were doing company secretary curriculum as a part of syllabus in chapter number 2, General and Commercial Laws, immediately after Constitution. Essential rules of interpretation of statutes was taught to us. And but this subject, this interpretation subject become very vocal. Lot of people started talking more about it post Companies Act 2013, because what used to happen under the old Act 1956 Act is Act was very static. The amendments used to happen once in a while. Whereas Companies Act 2013, SEBI regulations now, FEMA regulations, NBFC regulations, GST regulation, take it any regulation which is all these regulations have become very dynamic regulations, and therefore whatever interpretation experts derive and whatever interpretation is coming through commentaries, the shelf life of that commentary, the books has shrinked drastically, and therefore it is a need of an hour that every company secretary or every legal professional, be it a company secretary, chartered accountant, lawyers, we all have to be abreast with interpretation principles. And in this context, today's PPT I am sharing, uh, I will be talking to you on different aids of to interpretation, whatever are available. And this we have all learned that internal aids, external aids, and then some principles of interpretation. First principle which we will discuss is literal rule of interpretation. Second, we will discuss about harmonious construction. Then we will discuss about conflict between general law versus special law. We will also discuss about whenever there is an old act and an amended version, which one will prevail. So the latter will prevail, and when the latter will prevail, all of that also we will try to see. Mischief rule also we will look at. This is very popular principle which everybody talks about. Some Latin principle like ejus dem generis nocita racis, all those three principles also we will look at, and its repercussion in the context of Companies Act 2013. We will try to focus on that. We will also discuss some principles of when law uses the negative language and sometimes it uses the affirmative language, which provision will prevail. So that also we will try to discuss today. We will also discuss doctrine of impossibility of performance, and this doctrine has become very, very vital, very, very relevant in this COVID-19 scenario where Corona has almost locked down entire world, and there are curfews and there are restriction on movement, there are restriction on functioning of offices, and a lot of compliances have become impossible to comply. And then what is this doctrine of impossibility of performance, that also we will look at. We will also look at when is the law considered as prospective, when is the law considered as retrospective. Is it that every law is retrospective, or is it that every law is prospective? Now we will take one principle, one aid. We will also try to look at different examples, taking the clue from Companies Act or SEBI regulations, because we being company secretaries or you being company secretary students of Companies Act and SEBI, we encounter Companies Act related problems more than any other laws, regulations problems. And therefore, in this context now, let's start looking at these subjects one by one. Now, there are different aids to interpretation. Some are considered as internal aid to interpretation, and some are considered as external aid to interpretation. We will first take internal aids to interpretation. Uh, Now we are taking one. One first is long title. Now, when I'm reading any act, for example, SEBI prohibition of insider trading regulation, and whether the name, the title of that regulation or legislation, whether the name plays any role when you are trying to derive any meaning with respect to wordings of a particular rule, regulation, or section of that particular legislation, whether the name has any value as far as interpretation of the wordings of the law is concerned. Now, Indian judiciary systems have been very vocal about it. In Manohar Lal versus State of Punjab, Supreme Court held that name is a key to the construction of statute whenever acting part is open to doubt. What it means is, so if the law has, every law has a name, title, what we call in legal terms, then every law, every enactment has a title, and every enactment also has operating provisions in the form of sections or regulations. Now, when operating provisions have ambiguity or doubt, then the name always helps you in the construction. That's the first point which they are trying to say. Second important point, which in Manohar Lal case, Supreme Court held that name indicates the main purpose of the enactment, but it cannot obviously control express operating provisions. So, although the name indicates the purpose, but that doesn't mean that the specifically mentioned provisions will be superseded by the name's intention. Obviously not. That's what the second principle which Supreme Court had laid down. And third principle is objective of the name is identification of the law and not to describe the law. Description of the law will always come in the form of sections and subsections and all those provisions which are directly operating law, what we call. Now, my dear friends, I would also like to highlight here that reading any interpretation principle in silo, he will never tell us how to interpret a particular law or how to understand or how to apply these interpretation principles. And therefore, my endeavor would be to first of all give you an example, some examples of some laws or some provisions where this principle, this aid can be applied with. Number one. Number two is we will also see what the judiciaries have said about it. Because, my dear friends, interpretation is basically done exhaustively and extensively by high courts and supreme courts and all the tribunals and judiciaries. Because when two sides come in front of them and argue with respect to any particular matter, and each party is trying to get a judgment or an order or a verdict in their favor. And in that argument, they argue on a law point, facts and the law, both. And Supreme Court and High Court, Supreme Court deals only with the law point, and High Courts deal with law points and fact points, both. So when we read Supreme Court judgment, or when we read some High Court judgment, and when we see how they have implemented these aids of interpretation or principles of interpretation, then we understand that particular law better. And therefore, my endeavor in this discussion would be to share with you what are the aids and in which case how to apply, and has any judiciary applied that principle. Not everywhere I will be able to share because paucity of time. This is a very vast subject. It's like an ocean, and as deeper you go with more pearls. But just to give you an orientation or a recap of whatever we have been studying with respect to interpretation of statutes. The first internal aid which we are discussing about title, and we looked at three principles, that it is to describe, it is to identify law and not to describe. And when the main operating regulation has any doubt, definitely the name or the title gives us some hint about what the intent of the law is. But however, that intent cannot supersede the operating wordings of any particular law. And this was also held in Manohar Lal versus State of Punjab by Supreme Court. Now, let's take an example of SEBI prohibition of insider trading regulation. Now, the name of these regulation itself tell us that these regulations are to prohibit insider from trading. In what? So, in what is prohibited? So, trading in security, that comes when we read the regulations. So, insider is prohibited from trading, but what trading? That regulation will tell us that what is prohibited and when he is prohibited. That is also being narrated under SEBI prohibition of insider trading regulation. So by reading this particular title, we cannot arrive at any conclusion. However, if the text of that regulation has some ambiguity, has some unanswered questions, then this title can give us some answer. This is how we have to apply this one first internal aid of interpretation, that is long title. Second aid of interpretation which comes is preamble. Now in all legal enactments like acts or regulations, generally every act preamble. Now preamble tells us what's the intent or the purpose of the law which they are trying to solve. So in state of Rajasthan versus Leela Jain, again Supreme Court judgment of 1965, what they said is preamble may be used to solve any ambiguity in any law, but it cannot be used to eliminate the operating provisions of the law, same like title. Now what we are doing is, when we have to interpret a particular provision of any law, what is the relevance of the title? That's what we looked at in the first slide. Second, what we are trying to look at is, when I am interpreting any particular law, what is the use of the preamble of any statute? Now, can preamble dictate me? Can preamble supersede over the active provisions or the operating provisions of the law? No. But can preamble help me to construct when there is some ambiguity in the law? Yes. There is one more utility which Supreme Court has narrated in this state of Rajasthan versus Leela Jain case, where they say that preamble can be used to fix the meaning of a particular word which may have more than one meaning. So very, very important. Now we all speak English, but when you open, as a curiosity, if you open a dictionary before looking at any meaning of the word, you will see that almost 99.99999% words, you will see more than 1, 2, 3, 5, 6 meanings given to a particular word. Now, when dictionary is telling some 6 meanings of a particular word, what is the meaning of a particular word which is used in a particular section or a subsection of any law? How do I derive at the meaning of that word? Sometimes that helps us. Sometimes that the title of the regulation or the preamble of the regulation helps us to fix the meaning of a particular law. I'll give you an example. Securities Contract Regulation Act. Now, word security is a very vast word. It has multiple meanings. Now, sometimes security means charge or hypothecation or a mortgage. So, somebody is giving loan and against that it is taking some security for securing its loan. That is also called as security. And share, stock, bonds, debentures, or other marketable securities which are tradable in a stock market is also considered as a security. Now, which security is being dealt with? Which when we looked at that word, then when we look at the definition section of Securities Contract Regulation Act, and when we look at the preamble of Securities Contract Regulation Act, and when we look at the meaning title of the Securities Contract Regulation Act, and all of that we put together and try to read it, then we understand the meaning of the word security. So whenever there is any ambiguity with respect to any particular meaning of the word, And if the law has not defined that particular word, then sometimes preamble or a title can help you to fix the meaning of that word. That's what is trying to be said in state of Rajasthan versus Leela Jain. Some more internal aids of interpretation: marginal notes and headings. Now, again, every section has marginal notes and headings. Marginal notes are those notes which are inserted at the side of the section in the act and express the effect of the section. Now, these are also known as the side notes or a marginal notes. And every section has some heading. For example, section 437 of Code of Criminal Procedure Code 1973, it says the heading is when a bail can be taken in case of non-bailable offense. So the heading itself makes it clear what is the narration of that particular section, what is the description of that particular section. That is the bail, when the bail can be taken in case of a non-bailable offense. So in case of a non-bailable offense also bail can be taken, and under what circumstances that bail can be taken. That is explained in particular heading of that particular section. Marginal notes, headings, both of them help us to eliminate, both of us to help to interpret the law, but it cannot eliminate the operating provisions of the particular legislation. This is very, very simple, and therefore there is a limitation on the these usage of either a title or the preamble or the internal headings or the margin notes, margin or side notes. There is a limitation as far as use of these while interpreting a particular law. However, as various judiciaries have held in several pronouncements of theirs, it definitely has some utility in this regard. Uh, Now, some exception or saving clause. Now, let me tell you, for example, save as otherwise provided or except as mentioned in any other section. Now, these are the wordings which are used in Companies Act. In Companies Act, approximately at 80 occasions, either the word save as otherwise provided or the word except has been used in Companies Act alone, rules separate. Now look at the volume of the usage of this word in particular enactment. Companies Act is a 470 section long legislation and almost equivalent rule making powers to Ministry of Corporate Affairs, and MCA has been coming out with various rules and regulations, rules under Companies Act 2013 also. Alone in Companies Act 2013, at around 80 occasions, the word save or accept has been used. For example, in erstwhile section 185, now amended in 2018 May, it used to say that save as otherwise provided in this act, no company shall give loan to any director or entity in which director is interested. So saving section or an exception sections are generally added to the enactment with the purpose of exempting something which would otherwise fall within the ambit of the main provision. So, like we have saving clause, there is also deeming clause in deeming clauses in enactment, where, for example, public limited company's definition says a private limited, any company which is not a public company, which is a subsidiary of a public company, is also considered as a public company. So if it is a private limited company which is a subsidiary of a public company, it is deemed to be considered as a public limited company. So deeming is opposite of saving or exception. So exception or saving are generally added to enactment with the purpose of exempting something which would otherwise fall within the ambit of the main provision. And deeming are something which adds something which is otherwise not to be added. For example, as I told you, private company is not a public company, but if private company is a subsidiary of a public company, then it is deemed to be a public company. So similarly, 185 has to be, it used to say that save as otherwise provided. So accordingly, those constructions have to be derived, and therefore this one, another internal aid is also very, very important when we are trying to interpret a particular law. Now comes schedules. Very, very important part of the any act or enactment. Schedules attached to an act generally deals with as to how a claim or right under the act are to be asserted, or as to how powers conferred under the act to be exercised. The schedules are appended towards the end of the enactment. And like any other subordinated legislation, schedules are also have equivalent power read with the section. They have equivalent power like a main enactment. In Companies Act alone, there are 7 schedules like CSR schedule, or what is infrastructure, balance sheet, memorandum and articles, and so on and so forth. The duties of a director, independent director, schedule 4. So many schedules, 7 schedules have been provided under the Act, and schedules actually describe rights claims, or sometimes it is the deliberation elaboration of the main regulations. And generally schedule for finalizing schedule, that power is a delegated power to the respective ministry or to whoever is the in charge of that particular enactment, whoever is going to be the regulator, which ministry or whatever regulator is going to be in charge of the regulation, enforcement of those regulations. They are generally allowed to amend the schedules from time to time. Companies Act, we have seen recently schedule with respect to CSR was amended to cover COVID-19, and PM Care fund was covered under schedule with respect to CSR. So this is one more internal aid of interpretation. Very, very important internal aid of interpretation now we are looking at, and that is explanations. Very important. Now, this is another judgment which I am sharing with you. Is this is a case of S. Sundaram versus Pillai. S. Sundaram Pillai versus V.R. Pattabiraman. This is also Supreme Court judgment, 1985 judgment, and in this judgment they have tried to explain what is explanation. Explain what is explanation. They have laid down various parameters. I have picked up 2-3 important principles about what is explanation. An explanation is to explain the meaning and of the act itself, on the independent of the act itself. Where there is any vagueness in the main enactment, to clarify the same so as to make it consistent with the dominant object which it seems to subserve. So explanation is trying to explain what is to be meant by the particular wording of a particular section. However, can explanation demean, or can explanation derogate, or can explanation reduce the power of main enactment? It has laid down in the third principle of S. Sundar Raman Pillai case of Supreme Court, that it says that it cannot, however, take away a statutory right with which any person under a statute has been clothed or set as a knot, or the not working of the act by becoming a hindrance in the interpretation of the statute. A classic example, if SBO, for example, significant beneficial ownership regulations of Companies Act, under Companies Act 2013, these regulations, these rules came in the year 2018-19. And while defining what is significant beneficial owner, they have used explanation extensively. And out of that, explanation 3 is defining what is indirect way of holding. Now, SBO as a principle under section 8910 and under section 91, and under the definition, main charging definition of the SBO rules, it clearly says that when an individual directly or indirectly and alone or together with somebody, so he directly, indirectly, or together with somebody, if he controls more than a particular threshold of the voting power or dividend distribution right, or has a significant beneficial or has a significant influence over the other company, then that is considered as a significant beneficial owner. This is the principle. Now, what is indirect is explained in explanation 3 of SBO rules. Now, if any particular explanation of that schedule 3, if that explanation is going to puncture, or if that is going to dilute the original principle of significant beneficial owner, then that explanation will not be binding, and that explanation will not have, the explanation cannot be read in that way. That's what S. Sundar Raman Pillai case is telling us, that it cannot, however, take away the statutory right with which any person under a statute has been clothed. So a statutory right you cannot undermine, or it cannot become an hindrance in the interpretation of a particular law. It has to be a facilitator, and it is explaining, but it cannot narrow down the meaning of the original principle. One example is even under prohibition of insider trading regulation, explanations are given under various regulation 3, regulation 4. Everywhere they have tried to give explanation and illustration, just as to explain uh, what is meant by this particular regulation or a sub-regulation. In recently one case, Supreme Court had come out very openly that this is a good practice of explaining to the common man who is reading a law or a student of a law as to what is the intent behind this particular section or a rule, and therefore explanation has started playing a very vital role. However, if anybody uses this explanation as a tool for interpreting a law in such a way that it will reduce the original intent of the particular act or regulation, then that's not the right way of using this explanation. And this is what is S. Sundaraman Pillai case tells us. Some more internal aids of interpretation are provisos. Now, at least hundreds of occasions, you would say that as many number of sections, as many number of, or sometimes even more number of provisos are there in Companies Act. What is the meaning of the proviso? One fine day, one student had told me that Makaran sir, actually proviso he entire law. For example, particular provision says 135(5) says that every company has to spend, every company shall spend 2% of their average profits, net profits of the company on corporate social responsibility every year. And that the proviso says that while spending that money, you need to give preference to local area. And the second proviso says that if while spending that money, if you are unable to spend that money, mention the reason for not spending that money in the director's report. And therefore, how do you read the proviso? That was discussed and elaborated in Sales Tax Commissioner versus B.G. Patel, which is again a Supreme Court judgment of 1995. It says that ordinarily proviso is an exception to the main proviso, but in exceptional cases, a proviso can be substantive provision itself. Now, this was Ishwarlal, Thakurlal, Alambula, and Motibai and Nagibai case, where it said that provisos are generally exception to the main principle, but sometimes exceptional cases, proviso can be substantive provision themselves. And therefore, I was giving you an example of 135. 135(5) says that every company shall spend on CSR 2% of the average 3 years profit. Every year, company has to spend. And the proviso says that if you are unable to spend, then mention the reason for not spending in the director report. Now, should we read this proviso as an exception to subsection 5, or should we read this proviso as an additional compliance to the proviso? Just excuse me. And that is, judiciaries have been elaborating this in detail with the help of the proviso interpretation. And now the government has also made it very clear that as far as 135 is concerned, that if you are unable to spend, then you have to transfer that unspent amount to a separate escrow account if you in a separate account, and from that you can spend your ongoing projects for next 3 years. And otherwise, if you do not have a long-term project, then within 6 months the funds have to be transferred to a separate account, which will be constituted by central government under Schedule 7 of Companies Act 2013. So provisos sometimes are exceptions to the main principle, and sometimes proviso itself becomes a law. Like in this case, 135(5). One way of interpretation is that every company has to spend money, and if company is unable to spend money, mention the reason for not spending in the director report. The other way of interpretation is that every company has to spend money, on CSR, and if you are not able to spend money, then also mention in the director report. So we can treat it as two separate provision or reading it together, and it depends on case to case. Another case of sales tax commissioner versus BG Patel, it says that proviso must not be interpreted in a manner so as to render itself ineffective or to render substantive provision redundant. And therefore, what it means to say is proviso is either an exception or an addition, but it cannot nullify the main provision or it cannot nullify itself. And therefore, it has to be the original section of rule and the proviso both have to coexist together harmoniously. And that's how we have to read the proviso to the law. What we are doing is, what are the internal rates of interpretation? And when we are interpreting a particular law, how do you use explanation? How do you use marginal notes or heading? How do you use preamble or title? We are discussing that. Then we discussed about how do you use explanation while interpreting a particular law. An explanation is an explanation. It cannot supersede law. Similarly, proviso is generally an exception and sometimes it becomes a substantive law, but proviso cannot kill or proviso cannot nullify the main provision. And we have to interpret main provision and proviso in such a way that both of them can coexist and both of them live together. And that's how we have to interpret. And this we saw in Ishwar Lal Thakurlal case, and we also saw in BG Patel case of Supreme Court. So there are so many examples like 135 and as I was telling 203, which is the classic favorite, very close to every company secretary's heart, KMP. 203 scheme managerial personnel, that also uses the provisos. 135 uses provisos, 195 uses provisos. Every important section uses provisos. Almost you will find very rarely any particular chapter where there are no enough number of provisos. And as I was telling, provisos actually put a lot of color while we interpret a particular legislation. Now we are moving to external aid of interpretation. We covered internal aid of interpretation. Now we are moving to external aid of interpretation. Parliamentary debates. Whether parliamentary debate has any role to play. Now, this was a landmark judgment, State of West Bengal versus Union of India. Again, a Supreme Court judgment where it was said that how do you use parliamentary debate? Can I use parliamentary debate and rely on it while interpreting a particular law? It says a statute that's passed by Parliament is the expression of the collective intention of the legislature as a whole. And any statement made by an individual minister of the intention and the objects of that cannot be used to cut down the generality of the words used in the statute. For example, I remember when there was a provision getting inserted under the Companies Amendment Act, and Nirmala Sitharaman, our Honorable Finance Minister, was presenting Companies Amendment Bill 2 in the Parliament, and one member of Parliament raised a question that the provision which was proposed to be amended was with respect to demat of shares, and where it was stated that some shares will have to be mandatorily maintained in a demat form, and which companies have to do a demat mandatorily. That power was delegated to central government. And in that question and answer, and in the deliberation, parliamentary deliberation, one member of Parliament asked that whether private limited companies will be asked to do the demat of shares. And to that, Nirmala Sitharaman had replied saying that there is no, as of now, the ministry is not planning to go with a private company demat of shares, and it will be only for a public limited company. There was earlier Arun Jaitley, finance minister, he was Honorable Finance Minister later, Arun Jaitley, where he had also commented in one of the parliamentary debates about the 197 and whether it is applicable to private limited company. Now the question which came for a discussion with Supreme Court is, if such answers and if such discussions can tell us how do I read 197, or can they tell us how do I read Rule 9 with respect to demat of the provision? In that Supreme Court, in that context, Supreme Court said that it is one of the finance minister making any statement in the Parliament cannot supersede the words used in the Act. However, if there is an ambiguity, definitely whatever discussions have happened, and if there is an ambiguity, and if the parliamentary discussion indicates that this is what the intention was, then definitely it can be useful. So far so good. What we have used, what we have seen with respect to title or preamble, or with respect to marginal notes or headings, or even with respect to parliamentary debate, is one thing is coming out clearly, that whatever it is, these are supplemental aids to interpretation, and it cannot derogate the main provision. Similarly, even proviso cannot nullify the important provision. Explanation cannot nullify the provision, the section to which this explanation is provided. The explanation is always a subservient. It is always a facilitator. It cannot supersede. And this is how all the aids limitations is coming up. Definitely, it adds value when it comes to understanding what is the meaning of those words. And we discussed about 135 having used the word proviso. We discussed about SBO having used explanation. Definitely, it adds a lot of value for understanding of professionals like you and me while implementing SBO rules, or while implementing PIT regulations, or while implementing corporate social and responsibility provision. But it cannot nullify the main provision. That's the important point which we have seen so far. Report of law commission. That a lot of time law commissions are set up. A report of a law commission are entitled to a great respect, and as they are prepared by an experienced person after taking into consideration all relevant objects and sometimes evidence collected by them. And therefore, it is from several sources. They have been the various Supreme Court judgments have relied on reports of law commission. At many occasions, ministries or parliaments constitutes committees to look at a particular challenge or a problem with the economy or a society and come up with some suggestion, or they are mandated sometimes to come up with changes in a particular law, and those are also being looked at very respectfully by the Supreme Courts and the High Courts. And what it says is, if the basic purpose underlying the construction of a legislation is to ascertain the real intention of the Parliament, the aid which Parliament availed of, such as reports of special committee preceding the enactment, existing state of law, environment necessitating any enactment of a legislation, and the objects ought to be achieved, there is no reason why they should be denied by the court. So when we are understanding what is the intent of the law, the basic which the select committee reports on which Parliament has relied upon while framing the law definitely can be relied upon heavily. However, if there is a conflict between committee's recommendation versus the actual wording of the law, definitely it will not support, or it cannot supersede the wordings of the law. But if there is an ambiguity, definitely these committee reports can be very handy, can be very useful for interpretation. Some examples of so many committees were constituted under Companies Act 2013, just to give you a glimpse. Now, the one way of looking at this discussion would have been very academic, just reading one by one the aids of interpretation and principles of interpretation. But I have been making an attempt to link it to Companies Act or SEBI, so that all the students of Companies Act and Company Secretary students and Company Secretary members can be benefited by this, by linking it to what has been happening actually. So reports issued post Companies Act 2013. First was in 2015, that was a high-level committee on corporate social responsibility. Then was in 2016, there was a company law committee. Then there in 2018, there was this report of the committee to review the offence under Companies Act 2013. And this is popularly the decriminalization started after this particular committee report, which submitted a report in August 2018. Then we saw another report of a high-level committee on corporate social responsibility. This report was submitted on 7th of August 2019. And then we also saw a report of company law committee report on 14th November 2019. And these 5 reports have definitely added to amendments which have happened in Companies Act and the rules and regulations in it. The last external aid of interpretation which I'm going to discuss is legislative history and the background. For example, BUTS, that is banning of unregulated deposit regulation, that regulation came in the background of Sharda scheme, Sharda chit fund from West Bengal, and Rose Valley scam which happened. This was dealt with in some of the cases, like the Imperial Chit Fund Private Limited in liquidation versus ITO. Supreme Court held that in this case, Honorable Supreme Court held that due importance must be given to the legislative history and background that led to the enactment of Section 178 of Income Tax, and the crucial words occurring in 178(3) and 4 of them. So when BUTS will be implemented, or when Section 42 will be tried to be interpreted by Companies Act, definitely while interpreting Section 42, Satyam and what happened to Satyam and why Section 42 was required under Companies Act will definitely be coming in. There was amendment with respect to 212, that is with the power of NFRA for banning auditor. Now, when that particular provision will come for interpretation of NCLT, definitely, or any judicial forum, definitely the background of ILNFS, in which background NFRA got a power to debar auditor, will definitely get discussed in the judicial forum, and this will be an external aid which is definitely can be relied upon by the judiciary, and this is an external aid which can be relied upon by the professionals while deriving any opinion or conclusion with respect to any anomaly with respect to while interpreting a particular provision. Why this PPT is being asked, or why this PPT Institute has asked us to prepare, is basically to facilitate or share our views with respect to interpretation and how judiciaries have been using it and how professionals can use it so that we can advise our client or management in the right way. That's a very, very important thing which becomes very important. So far, so good. I have covered with the first task which was assigned to me, that is internal and external aids of interpretation. And now we are going to the rules of interpretation. And the first rule of interpretation, which is the golden rule of interpretation, or a cardinal rule of interpretation, is a literal rule of interpretation of statutes. This is a very, very basic rule of interpretation, and sometimes judiciaries have also held that there is no rule of interpretation and there is only one rule of interpretation, which is literal rule. Read the law as it is. Don't add your words. Don't ignore any words. Don't add your emotions. Don't add your compulsions. Read the language as it is and try to interpret. These are some of the bullet points that words of the statute must prima facie be given their ordinary and natural meaning. Plain and unambiguous words must be given full effect. While interpreting the provision of statute, neither the word can be added nor it can be deleted, and a section is to be interpreted by reading all of its part together, and it cannot permissibly to omit any part thereof. For example, Section 197(1) puts a restriction. You can open the book simultaneously. 197(1) puts a restriction on managerial remuneration, but while describing that, it uses the word public company. But in subsection 2 or subsection 4 or such other subsection 3, subsection 3 of 197 does not use the word public company, it uses the word company. Now, that's what they are trying to say, that while literal rule of interpretation, read the entire section and then try to arrive at the correct meaning of the word. When the words this is from Cable Corporation of India versus Commissioner of Legal. It's a 2008 judgment. When the words of a statute are clear, plain, unambiguous, then the courts are bound to give effect to the meaning, irrespective of the consequence. Whether I like it or not, the consequence, whether I like it or not, it has to be interpreted in a way which are unambiguous and clear. When the language is plain and unambiguous and admits of only one meaning, no question of construction. And therefore, all lawyers, when the matter goes to the courts, all legal professionals argue and try to create different meanings of the same words. And as I mentioned in my earlier discussion, that you look at dictionary meaning and you will find 2, 3, 4, 5, 8 meanings to a particular word, and therefore the need for interpretation arises when the matter goes to the court. But if really the words are unambiguous, if there is no iota of doubt as far as the use of the words are concerned, then there is no other rule of interpretation which we have to look at, and this literal rule of interpretation is the appropriate, correct, and good enough rule for interpretation. If the language of the act is sufficiently clear and the court has to give effect to it, however inequitable or unjust the result may be, in that case, the words of the statute speak the intention of the legislature. It has consistently been held that inconvenience is not a decisive factor to be considered while interpreting a particular fact. For example, now in COVID-19 scenario, companies, there is a lockdown all over India, and no business, no economic activity, and therefore companies might be suffering from losses in the year 2021. But in the past 3 years, they had profit, and when they will have to spend on CSR, however inconvenient it may be, unless and until there is a specific carve-out exemption given by under the Companies Act from 135. However inconvenient it may be, CSR will have to be spent. And as per the amended version of 135, which recently happened, that if which is that the amendment is yet to be given effect to, but the Amendment Act has been passed. It says that Amendment Act is passed. It says that there is a penalty provision for non-spending of CSR, and there is also a proposed amendment in CSR which says that if you don't spend CSR, if you don't comply with 135, then 2 times of the obligation of CSR money. So if the company was to spend 1 crore on CSR, 2 crores will be the penalty levied by the ROC on the defaulting companies. And this word used in 135 proposed is word is penalty and not fine. And penalty levying power has been delegated to ROC, and no court, no trial, no court trial in the NCLT or in the session court, but directly ROC can levy penalty. And therefore, howsoever inequitable it might appear to you, or inconvenient it might appear to you, if the literal rule is good enough to give conclusion, then no other interpretation can be relied upon, is what has been held by many Supreme Court judgments. So one of the landmark case with respect to Nizamuddin versus Kim Plus Sanmar Limited 2010, it says that if the language used is capable of bearing more than one construction, and if it results in absurdity or anomaly, such construction has to be rejected, and a preference has to be given to construction that brings into harmony with the purpose and avoid absurdity or anomaly. So therefore, whenever there is any unambiguous literal rule, is the rule which we have to rely upon. Very recently, in case of Sun Pharma Limited, NCLT Ahmedabad, I believe, had held that in this case NCLT rejected an outbound demerger of Sun Pharma on the grounds that when it comes to a scheme of arrangement and restructuring, section 231, 232, 230 talks about those, and there they have used the word scheme of arrangement or rearrangement, whereas 234 has particularly used the word of amalgamation and merger, and 234 has allowed cross-border merger and amalgamation, but 234 has not allowed cross-border demerger. And therefore, what it held, NCLT held, that if any provision of the law is clear beyond any ambiguity, it is to be implemented regardless of the fact that it causes hardship to a particular party. And therefore, although somebody tries to interpret 234 to say that it is in the family of the scheme of arrangement and restructuring, and therefore the word amalgamation and merger should be inclusive and it should cover demerger, judiciary, the NCLT has refused to accept this kind of interpretation, and they have said that since the lawmaker has used the word amalgamation and merger, therefore it cannot be construed as demerger. There is one more construction, that when there is the express words used, and then there is a meaning that the other words which are not expressed are not to be covered. For example, if the merger and amalgamation word is used and demerger is not used in 234, that means only merger and amalgamation is to be given effect while interpreting 234, and demerger is not to be given effect to. Demerger is not a word to be added. In the first 2-3 slides I had mentioned, in the second last bullet, you can see that while interpreting the provision of the statute, neither the word can be added nor it can be subtracted. So you on your own, you cannot add the word demerger when the lawmaker has used in 234 only the word merger and amalgamation. This is what NCLT has said in Sun Pharma case. So in literal rule, you cannot interpret a law as per your impulsions, emotions, compulsions. Nothing like that is useful. The language of the law is supreme. Inconvenience is not to be given effect, but the language of the law is to be given effect. You cannot copy paste the wordage of 231 into 234. 234 has used the word amalgamation and merger, and therefore all scheme of arrangement and rearrangement cannot be allowed under 234. That's what NCLT has said while interpreting a particular matter of Sun Pharma in the context of section 234. Now, but what happens is every time it may not be feasible to apply literal rule of interpretation, and sometimes when more than one section talks about a particular transaction, then how to deal with it is one dichotomy which starts telling us. For example, section 185 prohibits any loan, giving of any loan to any party in which director is interested, particularly if to the director himself or to his relative or to the firm in which he is a partner. 185 prohibits. 186 allows any loan you can be given so long as the board resolution is passed, so long as shareholder resolution is passed if it is required under subsection 2. And so long as public financial institutions consent is obtained if required under 186, and so long as the interest is charged, so long as you make an entry in the register of loan and investment, then you can give loan. So in that case, what will prevail? So this dichotomy we will try to discuss in this particular section. We are starting with harmonious construction. This is a Venkatramana Devaru at the state of Mysore against Supreme Court judgment of 1958. They say that the rule of construction is well settled, that when there are in an enactment two provisions which cannot be reconciled with each other, they should be so interpreted, if possible, to give effect to the both. That means both provisions should coexist. Both provisions should coexist. All the parts of the statute must be read together so as to make, as far as possible, a consistent enactment of the whole statute, giving full meaning of the and the effect to every part, and not rendering any part meaningless or superfluous. And therefore, harmonious construction tells us that when there are 2, 3, 4, 5 provisions dealing with a particular transaction, then all of them you have to give effect to. And therefore, a popular way of interpreting harmonious construction is when you have one provision which talks about board resolution, and another provision talks about shareholder approval, third provision talks about public financial institution, fourth provision talks about approval of central government. And if you have to give effect to all, that means you have to go to board approval, shareholder approval, public financial institution approval, and central government approval also. This is how, therefore, what common terminology is stricter with prevail. The lot of people synonymally use harmonious construction as stricter with prevail. So let's take an example, Section 179 and 186. Section 179 says that subsection 3 of 179 says that board of directors of the company shall exercise the following power on behalf of the company by means of a resolution passed in the meeting of the board. So following powers can be exercised by the company, by the board at its meeting, to invest the funds of the company or to give loan or to guarantee security in respect of the loan. Now, when you look at Section 186 subsection 2, it starts with a negative wording. No company shall directly or indirectly give any loan to any person or acquire by way of subscription, purchase, or otherwise security correct, where the aggregate of the loan investment so far as made exceeds or guaranteed security exceeds the limit of subsection 2. No investment loan shall be made or shall be given or security shall be provided unless special previously authorized by special resolution passed in the general meeting. So 186.2 says that when you are trying to give loan or making investment in the giving loan to the person, and if it exceeds the limit under subsection 2, then a special resolution of shareholder is must. What it means is 179 talks about board resolution, and 186.2 says that if you are exceeding the limit, you require approval of shareholders also. Therefore, board approval and shareholder approval. As I was telling, that 186 also mentions that in certain occasions you also need prior permission of public financial institution. So therefore, it has to be complied with. However, 186 subsection 11 says that nothing contained in subsection 2 onwards of 186 will be applicable to infrastructure companies when it comes to giving loan. Now, in that case, 186 is not applicable, only 179 is applicable. But if you are not an exempted company under 186.11, then 179 and 186 both have to be read together and both have to be given effect to. That means 179 subsection 3 also needs to be complied with, and 186.2 with its provisions also needs to be complied with. And when you have to comply with the both, then stricter will prevail. That's what we are trying to say. For example, if the company is trying to come, some examples which I have given in the bottom of the slide, sir. If the company is trying to come out with the issue of debentures, then you have to comply with section 42 and for section 71 also. If you are trying to come out with the convertible preference share, then you have to comply with 42, 62 and 55. So depending on what kind of transaction you are doing, and if you have multiple sections to be complied with, you have to comply it in such a way that all sections are given effect to. You cannot pick and choose one of the sections saying that I will comply with section 186 and I will not comply with 179, or I will comply with 179 and I will not comply with 186. You cannot take that view. You have to comply with the both. So this is principle number one when there are two provisions dealing with a particular transaction. Second situation arises is two provisions are applicable, but one is a general provision and other is a special provision. Then what will happen? And what is general provision? What is special provision? So what it says is when there is a conflict between special provision and special provision prevails over the general provision. Latin maxim generally are specialibus non derogant. That means also known as the rule of implied exceptions, meaning general things do not derogate from special things. So if there is a conflict between general provision and special provision, and if it is impossible to comply with both the provisions, then special provision should prevail over general provision. It is one very interesting analysis with N.S. Bindra in his book of Interpretation of Statute, 10th edition, page 557. What he says is where there is a general provision which, if applied in its entirety, would neutralize the special provision dealing with the same subject, then the special provision must be read as a proviso to the general provision. And then the general provision, insofar as it is inconsistent with special provision, must be deemed not to apply. So, for example, section 185 and 186. 185 says that if you want to give loan to a firm in which director is a partner, you cannot give loan. However, 186 says that you can give loan to any person by passing a resolution at the board meeting, and if the limit is going beyond limit, then you have to take the shareholder approval, switch by special resolution, and under certain circumstances, permission, prior permission from public financial institution, and so on and so forth. So, if there is a conflict between 185 and 186, which one will prevail? So 186 is about talking about loan given to any person, whereas 185 prohibition is towards loan given to a firm in which director is a partner. So 185 is very specific, and 186.2 is very, very general. And therefore, which one is a special provision? 185 is a special provision over, and therefore 185 will prevail over the 186. And therefore, if 185 prohibits giving loan to a firm in which partner, but director is a partner, and 186 allows you to give loan to anybody, then 185 will prevail over 186. Now here there are two provisions, and if you give effect to two provisions, then one provision is becoming redundant here. Which provision is becoming redundant? 186.2 becoming redundant because 185 first of all is not allowing you to give loan, and passing board resolution or shareholder resolution or public financial institution consent under 186 is not relevant at all. So that's what we read in this N.S. Bindra's interpretation, that special provision should be read as a proviso. And some slides back we looked at how the role of proviso is important in interpretation of a particular statute. Proviso is considered as an exception to the main rule. So the main rule is under 186.2, or a general rule is under 186.2, and special rule is under 185. And both have to be read together. And therefore, if one rule does not allow the other rule, then 186.2 will not allow a company to give loan to firm in which director is a partner. You cannot give loan. Therefore, if harmonious construction is not possible, then special will prevail over the general. There is in this same family we are continuing with when we have multiple provisions applicable, and that's how the complications come up as to what's the meaning of how to interpret a particular law. And whenever there is a conflict between general provision and special provision, then the latter will prevail. This is one more principle, that the latter will prevail. So when there is a conflict between general and special provision, the latter will prevail. In the Pretty versus Soli, it was quoted by Robili that the rule is that whenever there is a particular enactment and a general enactment in the same statute, and the latter, taken in its most comprehensive sense, would overrule the former. The particular enactment must be operative, and a general enactment must be taken to affect only the other parts of the statute to which it may properly be applied. So, whenever there is a conflict between old provision and the new provision, generally, and if the new provision is a special provision, then the special provision will prevail over the general provision, and the latter will prevail over the previous one. One example can come up in 135. Another example can come up in section 74. For example, repayment of deposit. Now what happens is when Companies Act 2013 came, section 74 says that where the company has accepted a deposit before the commencement of Companies Act 2013, the deposit taken under Companies Act, these deposits are required to be repaid. Earlier it used to say that within 1 year from the date of commencement, and then it got amended on 15th August 2018 to say that within 3 years from such commencement or before the expiry of the period of the deposit which were accepted. Now which one will prevail? 1 year will prevail or 3 year will prevail? In my view, in that case the latter will prevail, not the previous one, and therefore 3 years condition will prevail over the 1 year condition. Sometimes what happens is it becomes difficult to, there are not multiple provisions, but we are trying to interpret a particular provision, and while interpreting a particular provision, when we are trying to understand the intent behind this particular law, then the mischief rule comes very handy for us. And what mischief rule tells us is when the plain reading of the provision is not very clear, then in that case one has to apply an appropriate tool of interpretation to unearth the intent, object, and purpose of the mischief rule or purposive rule of interpretation to find out the true and correct meaning of the statute. Adopt a construction which suppresses the mischief and advances the remedy. For example, under Sahara case, Supreme Court observed that under the old Act 1956, there was no restriction on how many persons the allotment can happen in a year. For example, under Section 1956 of Companies Act, it used to say that the offer made to 50 persons at a time will be considered as a public issue. But there was no restriction. You can keep offering and allotting every day or after every half a day. There was no restriction on it. And thereby, can I say that I will allot to 50 people per day multiplied by 365 days? Is it possible? So that was a hypothetical possibility under the old Act. And that mischief was corrected by Companies Act 2013 by putting rightly a restriction that in a year, if you offer to more than 200 persons, offer to subscribe, offer to invite them to subscribe shares to more than 200 persons in a year, then it will be considered as a public issue. And this is therefore, if you have to apply how to read this 200 word restriction, then this particular background and the mischief which was trying to get corrected will always help us to understand this. In Apple Finance Limited versus Mantra Housing Construction, which was again a Bombay High Court judgment, it says that if two interpretations are possible, one which furthers the object of the statute and the other which defeats it or permits a cunning person to commit a fraud, the former which furthers the object of the statute must be given. And therefore, if it is very evident from the background of the legislation as to why this legislation has been amended or introduced, and if that particular mischief it is trying to get corrected, then definitely that has to be applied with. In a recent case of a Yes Bank Limited, SEBI, while emphasizing what is the meaning of encumbrance, had relied upon this mischief rule. Now, what is encumbrance was mentioned in SEBI takeover regulations, and it got amended very recently. And then, while interpreting that particular case, SEBI said that while applying the disclosure obligation with regard to encumbrance, so as to achieve the objective of the disclosure, it is also important to keep in mind the mischief which Regulation 31 read with 28.3 of SEBI SHT regulation purports to limit. The genesis of the obligation to disclose encumbrance arose in 2000, way back in 2009 after Satyam scandal, when promoter shares were pledged to financial institutions and it was unknown to the shareholders, and therefore this encumbrance restriction came in. And therefore, any interpretation of the word encumbrance, if you try to derive which is defeating the purpose or which is trying to defeat the mischief which was trying to get corrected by that particular provision, then that interpretation is not right. And we have to look at what is the mischief which was trying to get corrected by the particular amendment or by particular enactment, and then accordingly try to interpret this particular law. We will now discuss some more rules of interpretation, and three Latin principles which are very common and very popular are ejus dem generis, the rule of expressio unicis, erst excluso alterius, and nociter rossis. Ejus dem generis is a consistent list of rules. Nociter rossis is also another rule, and expressio unicis exclusio alterius is also one Latin rule of interpretation. Very, very important principles, and which we will use. You as a company secretary must be using and will use these principles at several occasions. Like we will use interpretation of proviso at several occasions. Like we will use explanation at several occasions. Like we will use those 5 committee reports of Companies Amendment Act, 5 committee reports which we saw in earlier slides. We will use those while interpreting. Then while we use mischief rule while interpreting Section 42, or we'll try to use mischief rule while understanding what is meaning of encumbrance in the context of Satyam, in the context of NDTV case, and so on and so forth. Similarly, ejus dem generis is the one principle which we will use at several occasions. Where there are general words following a particular specific word, then the general word must be confined to the things of the same kind. It was held in Casher versus Holmes in way back in 1831 that all other metals following the particular word copper, brass, and tin did not include silver and gold, because the latter metals being a superior kind than a particular metals mentioned earlier, and therefore copper, brass, or tin and all other metals cannot include silver and gold. That's what Casher and Holmes had discussed with. And there is one more judgment on of Union Bank of India versus Pijushi Kanti Nandi, which was again one more very, very landmark judgment. It says that if a list of things of a particular type concludes with catch-all expressions like anything else or like otherwise, then this ejus dem generis principle has to be applied. Principle underlying the approach to statutory construction is that subsequent general word were only intended to guard against some accidental omission in the object of the kinds mentioned in the earlier, and were not intended to extend the object of a wholly a different kind. I have a classic example of ejus dem generis. For example, if the legislature says tiger, leopard, and any other animal, then you cannot consider cat or dog or cow into it, because the first examples were wild animals examples. Then the ejus dem generis will prevail. However, if the wording says that tiger, cat, fish, eagle, or any other animal, then it would not only include the animals, but it may also include the birds. And therefore, the last bullet, what we are trying to say, if no class can be found from the earlier words, then ejus dem generis rule is not to be attractive, and such broad construction as subsequent word may admit will be favored. So if you see a specific words and then there is a general word like otherwise, etc., all other animals, all other people, then that specific word will define the general words limitations, right? If the earlier words are not specific words and general words, then the subsequent words are which are otherwise or others, etc., has to be used in a very broader sense. And remember my example of tiger and leopard, and remember my example of tiger and cat and eagle and fish. So let's just remember that particular example, and you will understand ejus dem generis in detail. One more point which I have not covered in this PPT is that ejus dem generis, although it has to restrict, it cannot be used for anything and everything. In the sense that the generic words used cannot be used for anything and everything, but ejus dem generis cannot also be used to derail the intent of the law. And this has also been held by many judicial pronouncements, and therefore curious minds can please refer to some more judgments on ejus dem generis. Some example of section 188, for example, where the office or place of profit is trying to get elaborated, where it says that where such office or place is held by an individual other than a director, or by a firm, private company, or other body corporate, if the individual firm, body corporate, private company, or body corporate holding it receives from the company anything by way of remuneration, salary, fee, commission, perquisite, any rent-free accommodation, or otherwise. Now, what is that otherwise? No, otherwise has to be read in the context of monetary compensation. Otherwise should not be interpreted to include anything which is not remuneration at all. For example, reimbursement of the official traveling expenses cannot be considered as office or place of profit, right? It's not remuneration at all. It's completely different, and therefore, or otherwise has to be read in the context. And as we see in the earlier slide, what it says is look at bullet number 2. That the subsequent general words were only intended to guard against some accidental omissions in the object of the kind mentioned earlier. So this is a particular example. They have narrated remuneration, salary, fee, commission, rent-free accommodation, or otherwise. So if there is anything other than the words appearing above, but it is in the form, in the context of remuneration or a compensation, then it will be covered. But something which is not compensation at all, that need not be covered under it. Now we are going to next principle. Next principle is expressio unicis exclusio alterius, the full list rule, which means that a canon of construction holding that means implies one thing implies exclusion of the other. And the alternative, for example, if it uses the word each citizen is entitled to vote, and it is silent about non-citizens, that is presumed that only citizens are allowed to vote, and other people who may be resident but not citizen are not entitled to vote. Some more examples of this principle. If it uses the word weekends and public holidays, then it excludes ordinary weekdays. If it uses the word working days, then it excludes non-working days. The word members of a holding equity share, then it excludes members of holding preference share. If it uses the word annual general meeting, then it excludes extraordinary general meeting. So we need to remember this, that whenever there is a specific word mentioned and when it is other terminologies or other parts are not used, but then that those has to be interpreted in a proper way. So weekdays, weekends and public holidays cannot include weekdays. Weekdays cannot include weekends. So this is how we have to interpret. Now comes nocita rosis. Very, very important principle. We were discussing about 3 Latin principles, and this is the 3rd Latin principle which we are discussing. When word is known by the words with which it is associated, or around which are surrounding it. For example, sepals, nails, pins, snakes. The word nail here obviously does not refer to fingernails, right? So this is assumed because the nail word has to be read in the context of the surrounding word like staple and pins, right? So therefore, this particular nocita rosis principle can also be relied upon by all the students of interpretation while reading a particular enactment. So if it uses the word loan, debt, debenture, then that debt has to be read in the context of the surrounding word loan or debenture, right? So loan, comma, debt, comma, debenture, that debt cannot be any debt. It has to be read as per nocita rosis in the context of surrounding word that is loan or debenture. So I just gave you an example, and this particular example can be useful to you while interpreting Schedule 5. We are going to the next principle of interpretation. Just to take a recap, we looked at interpretation of statutes, and we first looked at internal aids, then we looked at external aids of interpretation. We looked at their utility. We also looked at their limitation. Then we started looking at various rules of interpretation principles. We looked at literal rule, which is the golden rule or the cardinal rule. Then we looked at harmonious construction. Then we looked at general law versus special law. Then we looked at latter versus previous one, which one will prevail, and how to read different provisions which are applicable to one transaction. How to read it harmoniously when harmonious interpretation is not possible. Which one will prevail? Special will prevail or general will prevail. We looked at various examples like 135, 185, 42, 62, 71, 55. So many sections which we have been referring to. We also looked at ejus dem generis and nocita rosis principles, which are very, very relevant. And whenever there is a generic word is used at the end, then ejus dem generis. When generic word is used between 2 specific words, then nocita rosis. So these principles are very, very important. Now we are moving further, and negative language is a mandatory character. If the statute is couched in a negative language, then it is ordinarily considered as a mandatory measure. The word shall not or shall not consider as a very mandatory measure. 2 examples I have given of a negative language. Section 68 of Companies Act 2013. We say that no company shall purchase its own shares or other specified securities unless it puts clearly no. Section 185 says that no company shall directly or indirectly advance any loan or guarantee or provide any security to any director or so and so. So no company shall. So no and shall. These 2 combinations is a deadly combination. And whenever there is such wording used, then it is a mandatory nature. And if these sections conflict with any other section, then these sections will have a superseding effect over the other section. Or you can consider that these sections are special provision and the other sections are general provision. So negative language is very, very important. Doctrine of impossibility of performance, and this is a very tough to understand. But it says that it is based on legal maxim, which says that tell us that law does not contemplate something which cannot be done. So if there is one law which prohibits more than 5 people coming together due to curfew 141, and there is another law which asks us to call for shareholder meeting where thousands of shareholders will be sitting at one place, cannot override, which is impossible for me to hold physical meeting. And therefore, if somebody holds a general meeting, I believe doctrine of impossibility of performance can come for his rescue. It was held by in the Sai Baba versus Bar Council of India against Supreme Court judgment, where it was held that where a statutory provision provided time limit of within 30 days of the date of the order, and a person cannot comply with it due to the late receipt of order. It was held that the expression the date of that order should be construed as meaning the date of communication or knowledge of the order to the review petitioner. A construction which would render the provision nugatory ought to be avoided, and therefore when it is impossible, then it has to be interpreted accordingly. So this impossibility of performance is to be applied in the rarest of the rare case, but such situations in COVID-19, this is very, very useful interpretation principle. And I think few last principles are prospective and retrospective operation of any statute. Generally, whenever there is any amendment to any act, it is presumed that all those acts, all those amendments are always prospective. As to a new statute or any amendment to the existing statute, a question that often arises as to whether it is retrospective, that is, should I give effect the prior date or should it be prospective? I think it is very clearly held in many cases, and some where in Keshav Madhav Menon versus State of Bombay in Supreme Court case, where it said that every statute is prima facie prospective, unless it is expressly or by necessary implication made to have retrospective operation. Unless there is a clear intention expressed that a statute would apply retrospectively, it cannot be given a retrospective effect and would always operate prospectively. This was held in several cases. It was held that it was always be held prospective, and this was also discussed by Madras High Court case in recently in the for 164 judgment, section 164, which talks about disqualification of director, and this provision became effective from 1st April 2014. And it said that any company which has not filed returns for 3 years, then the director, corresponding director of that particular company, will be disqualified for acting as a director in any other company for the next 5 years. It was stated that ROC has applied a wrong financial year for giving effect to this provision, and they have given effect from 1st April 2013, whereas the act came into effect from 1st April 2014, and therefore 3 years should have been counted from 1st April 2014 and not from 2013, and therefore could apply the one established rule of interpretation, which is unless a contrary intention appears, legislation is presumed not to be intended to have retrospective operation. Law passed today cannot apply for the events which have happened in past, and this is very, very just and fair and equitable. And this similar situation also arises in Vodafone case, which was fought between Vodafone and Government of India. Ultimately, in Supreme Court, the judgment went in the favor of Vodafone, and then government amended the law retrospectively from 1960. Similarly, in Section 274 of 1956 Act, which provision became effective from 13th of December 2000, but Section 274 was given effect from 1st April 1999. So these are some examples where wherever the law wants it to be retrospective, it provides the date, and if the date is not provided, all laws are always considered as prospective. And therefore, I'm just coming to the end of the discussion. That what we discussed in today's session is literal rule is the golden rule, and deriving correct meaning of the word is very, very important. And literal rule is not sufficient, and most appropriate rule has to be applied. For example, whether to apply harmonious construction of the principle, or whether to apply ejus dem generis, or whether to apply general versus special, or latter versus the new one. What is the principle? There is no hierarchy of the principle. Whatever is most appropriate to serve the cause, that principle has to be applied with. And reading judgment will always give insight into interpretation. One cannot master interpretation principle unless and until he develops a habit of reading judgment. And with this, I will conclude today's session. And thank you all for listening to this session carefully. And I hope this session you find it useful. You find this session useful. So that's it from my side. And I think we can conclude the session. Thank you.